activity gives you money, it is acceptable. Little wonder the executive chairman of the EFCC talked about the large number of lawyers being prosecuted. The Honorable Attorney General of the Federation is presently spearheading the amendment of the Legal Practitioners Act, which seems to overhaul the architecture regulating the legal profession in Nigeria. And I will not fail to use this opportunity to thank the body of benchers and the Office of the Honorable Attorney General of the Federation for the role they have played in this. The topic chosen for today's lecture shows that we should be interested in what happens beyond gathering here every now and then to perform the ceremony of admitting new entrants to the bar. We should care about their professional development. We should care about their ethical compliance with the rules. We should care how they and those of us who behave and act, and we should care to ensure that we don't unwittingly give the impression that the practice of the profession of law is one that can be used to aid and abet the commission of crime, or that a lawyer should be freely available to be engaged in any activity. I look forward to listening to the keynote speaker and the panelists talk about beyond call to the bar, because it is very important. We want the world to see ministers in the temple of justice, because we must be seen to be that. I thank the organizers for choosing this topic and for selecting the keynote speaker and other panelists. And I did thank Chief Awomolo for instituting this lecture under his chairmanship. And also to say that the bar will continue to be in support of this and every other measure that ensures that the number of law faculties being set up to teach law, the number of persons who are being admitted to read law, because the large number I referred to earlier is a product of every university wanting to read law and wanting to have higher and higher number of students to teach law, and welcome the decision by the federal government to have a freeze on the number of tertiary institutions being set up. But then this is not time for long speech. I've just been called to give a goodwill message. And so at this juncture, I should sit back and wish us fruitful deliberations. Thank you very much.
Thank you so much, Mr. President of the Nigerian Bar Association. Thank you. My noble lords, distinguished benchers, a whole lot of things at the court of Nigeria, and by extension, in the Nigerian judiciary. The use of technology is being optimized at a rate that we have never seen before. From the entrance of the Supreme Court, you would be greeted with biometrics machine used to record staff attendance. And the inner workings of the court's registry have been improved by digitization of receiving and data entry units, as well as the exhibits and judgment pasting units of the registry. Also, the notary public unit of the Supreme Court of Nigeria has transitioned from a manual application process to an online application system. In the context of the theme of this annual lecture, we all are aware that after the call to bar by the body of benchers, enrollment of new lawyers are manually done at the Supreme Court. Most of us must have written our names on the big book. At the legal year ceremony that's held last year, we got to know from the Honorable Chief Justice of Nigeria that the Supreme Court has now achieved full integration of the enrollment units with the Nigerian Law School through an online platform for new lawyers. I believe that deserves a round of applause. My lords, distinguished benchers, there is definitely a reformer par excellence at the helm. My lords, distinguished benchers, ladies and gentlemen, kindly rise if you are able and join me in warmly welcoming the Honorable the Chief Justice of Nigeria, Honorable Justice Kudirat Motomori Olatokunbo Kekereekun, Grand Commander of the Order of the Niger, as she delivers a speech and declare open this annual lecture. My lord, please. Thank you.
Thank you. Please have your seats. My Lord, the Chairman, Body of Benchers, Honorable Justice Olukayode Ariwola GCON, the Vice Chairman, Body of Benchers, His Royal Majesty Albert Akwamuji, Senior Advocate of Nigeria,
Life Bencher. The past chairman of the body of benchers, the Honorable Attorney General of the Federation and Minister of Justice, Prince Lateef O. Fagbemi, Senior Advocate of Nigeria, Life Bencher, the President of the Nigerian Bar Association, Mazi Alfa Mosigwe, Senior Advocate of Nigeria, Life Bencher, distinguished life benchers and benchers, the keynote speaker, Professor Wahab Egbewole, Senior Advocate of Nigeria, Vice Chancellor, University of Ilorin, invited guests, ladies and gentlemen. I'm indeed honored to be part of this second edition of the Body of Benchers annual lecture and the presentation of the reports of the directions of the Legal Practitioners Disciplinary Committee. The Body of Benchers occupies a place of rare distinction within the architecture of our legal system. It is the highest regulatory body for the legal profession in Nigeria. It stands at the confluence of history, honor, and responsibility. From the earliest foundations of legal practice in Nigeria, traceable to the Supreme Court Ordinance of 1876, the legal profession has evolved through deliberate regulation, principled leadership, and enduring commitment to ethical discipline. The body of benchers has remained central to that journey. Regulation is the backbone of every enduring profession. Through the solemn rites of call to bar, the body admits qualified persons into a vocation that is both noble and demanding. Yet, its responsibilities extend far beyond ceremonial admission. The maintenance of standards, the preservation of discipline, and the protection of the profession's integrity are continuing obligations that shape public confidence in our justice system. The Legal Practitioners Disciplinary Committee, operating under the authority of the body, carries a weighty mandate. Its work often unfolds quietly, away from public applause, but its impact is profound. By addressing professional misconduct with fairness and firmness, the LPDC reinforms the values that define our calling. Accountability, when administered with due process and impartiality, strengthens rather than diminishes the profession. One of the distinguishing features of the body of benchers is its composition, a thoughtful fusion of both the bench and the bar. This institutional partnership reflects a shared custodianship of the legal profession. The strength of our justice system rests upon mutual respect and common purpose between those who adjudicate and those who advocate. The body of benchers embodies that unity. The institution of this annual lecture is a commendable initiative. It provides an avenue for reflection, dialogue, and intellectual renewal. The theme of the maiden lecture last year, on 26 March 2025, encouraged a thoughtful appraisal of the body's journey over 5 decades. That exercise in institutional memory was valuable. History, when carefully preserved, guides present responsibility and shapes further future direction. The theme for this year, Body of Benchers Beyond Call to Bar, is equally apt. It invites us to consider the broader influence of the body in shaping the ethical climate of the profession. Admission to practice law marks the beginning of a lawyer's journey. Sustaining standards throughout that journey requires vigilance, mentorship, discipline, and example. Members of the body of benchers carries symbolic and practical membership of the body of benchers carries symbolic and practical significance. It reflects distinction earned through service, integrity, and professional excellence. Those who sit within its ranks bear the collective expectation of leadership by example. The moral authority of the body is sustained by the personal credibility of its members. The Nigerian legal profession has long been regarded as a model of ethical structure and intellectual depth. Across generations, it has produced advocates, jurists, scholars, and public servants who have shaped national development and defended the rule of law. That heritage places upon us a continuing responsibility. Professional integrity must remain visible in conduct, in advocacy, and in public engagement. Now, though I didn't make it part of my remarks, the Legal Practitioners Privileges Committee has made a public statement regarding the um, so called Blue Silk. The Legal Practitioners Privileges Committee is the only body that has the legal authority to confer rank of distinction on legal practitioners. I also commend the sustained efforts to compile and publish the directions of the Legal Practitioners Disciplinary Committee. The systematic reporting of these decisions contributes meaningfully to the development of professional jurisprudence. It enhances transparency, promotes consistency, and provides valuable guidance to practitioners and scholars alike. As we look forward to the keynote address by Professor Wahab Egbewole, Senior Advocate of Nigeria, a most distinguished academic, Senior Advocate of Nigeria, and Vice Chancellor of the University of Ilorin, we anticipate insights that will deepen our collective understanding of the evolving responsibilities of the body of benchers. Thoughtful scholarship and practical experience, when brought together, enrich institutional reflection. Gatherings such as this remind us that the legal profession is sustained by more than rules, it is sustained by shared values. It thrives when integrity is honored, discipline is fairly administered, and leadership is exercised with humility. It is on this note and with great pleasure that I declare open the 2026 annual lecture of the Body of Benchers. May our collective efforts continue to profession and the administration of justice in Nigeria. Thank you for listening, and may God bless the Federal Republic of Nigeria.
Please send a round of applause for my Lord as she takes a seat. Thank you, my Lord. With the swearing in last week of Honorable Justice J.O.K. Oyewole, JSC, the Supreme Court now has its full 21 constitutional complement of the court. And today we are gladdened to have with us some of our noble justices of the apex courts of Nigeria, who also are benchers. And I have with me my Lord Honorable Justice John Okoro, CFR. My Lord, you are most welcome, my Lord. We're also privileged to have with us Honorable Justice Uwani Abaji. My Lord, you are most welcome. I also know my Lord Honorable Justice Ellen Moreni Keji Ogunwumiju, CFR is around. My Lord, you are most welcome. We're also privileged to have with us Honorable Justice Jomai Sankey. My Lord, you are most welcome. And my Lord, we also doubles as one of our panelists today, Honorable Justice Chidebere Nwaoma Ua. My Lord, you are most welcome. We thank you for all the sacrifice and all the good job that you are doing at the Apex Court. We also have with us the DG of NOTAP, Madam Obiageli Amadiobi, who is representing the Minister of Innovation, Science and Technology. You're most welcome, ma'am. We're also honored to have with us the Chairman of Investment and Security Tribunal. Please, wherever you are, you're most welcome. Thank you. And we are privileged to also have with us the NJC Secretary, Mr. Ahmed Gambosali. You're most welcome, sir. Thank you so much. Now we are getting to the meat of this event. My noble lords, distinguished benchers, ladies and gentlemen, introducing the keynote address and the keynote speaker is somewhat personal for me for two reasons, and I will explain. First, the topic itself. Late last year, Late last year, I spoke at the International Bar Association conference in Toronto, on the application of the fit and proper character test for admission to the bar in Nigeria. In preparing that paper at the IBA conference, I had to interrogate closely the core functions of the body of benchers, and I recall having very long conversation before my session with my president, the former president of the Nigerian Bar Association, Mr. YC Mekia OONSAN, and who also is a member of this distinguished body. Shortly afterwards, in December, I shared a podium at the NBA Asaba Law Week with a former Attorney General of Delta State, a longtime prosecutor before the LPDC, and a life bencher, Mr. Charles Ajuya, Senior Advocate of Nigeria. And again, our discussion centered on the evolving role of this very esteemed body. Yet, even after those engagements, I still found myself asking deeper questions about the place of the body of benchers beyond call to bar and discipline. It is therefore very fitting that today's keynote directly addresses that broader conversation. Now to our keynote speaker. Professor Wahab Olashukbo Egbawale, Senior Advocate of Nigeria, was called to the Nigerian bar in 1985. He established the law firm of Wahab Egbawale and Co. in 1995. Over the years, Professor Egbawale has distinguished himself both in practice and scholarship, particularly in constitutional law, jurisprudence, and the intersection between law and social change. In recognition of his contributions to advocacy and development of law, Professor Egbawale was conferred with the rank of Senior Advocate of Nigeria in 2018. Beyond the courtroom, Professor Egbawale has built a remarkable academic career at the University of Ilorin, where he joined the faculty in 1997, became Professor of Jurisprudence and International Law in 2012, and in 2022 was appointed the 11th Vice Chancellor of the university, putting Professor E in the exclusive class of legal practitioners who have attained the zenith for courtroom advocacy as a Senior Advocate of Nigeria, academic distinction as a Professor of Law, and administrative leadership as a Vice Chancellor. A round of applause for him. Professor Egbawale also serves as the Chairman, Steering Committee of Association of West African Universities. My noble lords, distinguished benchers, these combined experiences as practitioner, scholar, and academic leader uniquely position him to engage the theme of this lecture beyond call to bar, and how institutions like the body of benchers can evolve to meet contemporary expectations of professional regulation, ethics, and leadership within the legal profession. Now, on a very personal note, Professor Egbawale was my teacher at the University of Ilorin for 5 years, one of the very best. It is therefore quite surreal that 15 years later, I find myself back in Prof's classroom as he addresses many of the questions we continue to ask about the future and functions of this distinguished body. My lords, given his depth of scholarship, practical experience at the bar, and leadership within legal education, and from my own vintage knowledge of him as a student, I can assure you that we are in for a great and engaging ride as he discusses his paper titled Reimagining the Nigerian Body of Benchers, Functions, Reforms, and Prospects. My Lord, the Chairman of the Body of Benchers, my Lord, the Honorable, the Chief Justice of Nigeria, distinguished benchers, ladies and gentlemen, please join me in welcoming Professor Wahab Olashukbo Egbawale, Senior Advocate of Nigeria, Vice Chancellor of the University of Ilorin, as he delivers the keynote address. Professor.
My Lord, the Chairman of Body of Benchers, my Lord, the Chief Justice of Nigeria, the learned Attorney General of the Federation, please permit me to adopt the well-established protocol. I want to start by appreciating and thanking the Chairman, Body of Benchers, and other distinguished life benchers and other members of the body for the invitation to deliver the second annual lecture of the body of benchers. I recognize this great honor and I will continue to cherish it for the rest of my life. Thank you, my Lord, and other members. I also want to appreciate the body of benchers for instituting this introspective approach to the workings and functions of the body of benchers. And of course, in that wise, I appreciate the initiator of the idea, Ashiwaju Adegboyega Awomolo, Senior Advocate of Nigeria, former chairman, body of benchers, and his team for putting this idea together. Let me take the liberty to call attention to the topic, body of benchers beyond call to bar, which is the general theme. I decided to reflect on that which is beyond call to bar as a function of the body of benchers, and therefore intend to address distinguished members of the body of benchers today on reimagining the Nigerian body of benchers, functions, reforms, and prospects. And this lecture, coming after that of another giant, Babatunde Raji Fashola SAN, former governor, former minister, I want to believe that we will just take off from where he stopped last year, March. I have also structured my paper from the perspective of 9 sections, starting with the introduction. I would give a theoretical framework to what I feel should be the essence and the basis of this body. Provide a brief history, I'm not going to dwell much on that, of the legal profession. I also will gloss over the brief history of the body of benchers. I would take some time on the membership of the body of benchers, powers and functions of the body of benchers, try to see what happens in other jurisdictions by cross-country analysis, and of course, give my recommendations and conclusions. The legal profession occupies a unique position in society, and I have interacted with the organizers. I understand I have 1 hour, but I have decided to stay within 30 to 35 minutes. A unique position in society as a custodian of justice. In Nigeria, the institutional architecture governing legal education, admission, discipline is shared among several bodies, notably the Council of Legal Education, the Nigerian Law School, the Supreme Court of Nigeria, and the body of benchers. The body of benchers, the body with statutory authority, among others, to enroll persons seeking to engage in legal practice in Nigeria and to enforce discipline at the bar in his role as the regulator of professional conduct. His mission and vision are clearly stated on his website. His mission is to, among other things, uphold the integrity and excellence of the legal profession by administering fair and rigorous assessment for the former call to the bar, nurturing ethical conduct, and fostering continuous professional development. We will interrogate this very soon. Its vision, amongst others, is to be the beacon of legal professionalism, setting the standards for legal education, qualification, and conduct worldwide. The emphasis of the body of ventures vision and mission is excellence, integrity, ethical conduct, and professional development. These values represent Nigerians' expectations of the product of the body of ventures. Have these expectations been met? Are there indications that the criteria used for the call to bar protect the values identified in the vision and mission of the body of ventures? Nonetheless, its most well-known function is to call aspiring legal practitioners to the Nigerian bar. Thus, the body of venture is often perceived narrowly as a ceremonial body responsible primarily for the call to bar. This necessitates interrogating this perception, providing a prognosis for this narrative, and creating a debriefing of this notion. This perception, however, understates the breadth and significance of its statutory mandate. Established as the apex professional regulatory institution for legal practitioners, the body of ventures plays a crucial role in maintaining professional standards, enforcing discipline, and shaping ethical conduct within the Nigerian bar. The overarching role of the body of ventures is to safeguard the integrity, dignity, and competence of the legal profession in Nigeria. It does so by regulating admission to the profession, enforcing discipline through its disciplinary machinery, and setting ethical benchmarks for legal practice. The question then is, why this narrow confinement of his role? The only possible explanation is that the perception from the activities of the body of venture is that narrow mirror. Possibly, the effect of other roles are not felt by the society or the body, has been largely dormant in other activities, or the body has not provided the appropriate narrative. These are undoubtedly laudable, and it can be said that for decades, the body of venture has discharged this onerous responsibility with grace. However, human organizations established to manage human beings must encounter challenges in that duty by virtue of their very nature of mankind. Inevitably, members of the legal profession, young and old, run afoul of the ethical requirements of their vocation and bring not only the management but also managers themselves into sharp. From its establishment about 64 years ago, the body of 54 years ago, the body of ventures has essentially maintained the same structure and performed the same functions. Reform is important to ensure that performance, and 6 decades is definitely long enough to compare reviews of possible reforms of the regulation of the legal profession with efficiency, prudency, and perhaps independence as the focal points of this exercise. This paper interrogates the functions of the body of this exercise. This paper interrogates the functions of the body of ventures beyond the ceremonial function of the call to bar and argues, amongst others, for a reconfiguration of its structure to enhance its relevance in contemporary legal practice and the overall performance of its functions in line with global best practice. This presentation is structured to address the theoretical framework and the details that I've given earlier. Theoretical framework. This paper is grounded in established theories of regulatory governance and institutional that provide analytical lenses for examining the body of venture and functioning. The regulatory capture theory, as articulated by Stigler in 1971, posits that regulatory agencies created to act in the public interest may eventually come to serve the commercial or political interests of the dominant groups within the regulated industry. Applying this theory to the body of ventures, it raises questions about whether the composition of the body, which is dominated by judicial officers and senior practitioners, creates conditions in which the profession's interest may override public interest considerations in disciplinary matters or admission standards. The persistence of life branches and supernumerary positions, despite their questionable contribution to regulatory efficiency, may reflect what public choice theory identifies as rent-seeking behavior. The institutional isomorphism popularized by DiMaggio and Powell, when applied to the paper, further explains why the body of ventures has maintained its structure for more than 5 decades despite the environmental changes. This concept describes how organizations become more similar over time through 3 mechanisms: coercive isomorphism, which connotes pressure from external authorities; mimetic isomorphism, which connotes copying successful peers in conditions of uncertainty; and normative isomorphism, which connotes pressures towards professionalization. The body of Bencher's resistance to fundamental change may reflect these isomorphic pressures, particularly normative isomorphism, arising from the legal profession's inherent conservatism and reference for tradition. Understanding these theoretical underpinnings is essential for crafting reform strategies that can overcome institutional challenges. This position is informed by the fact that what is constant in life is change. As the body of benchers given credence to this view, or as it by its actions faulted this position, these are part of the issues that this paper seek to address. Talking about the history of the profession, referencing back to Supreme Court Ordinance of 1876, the statute that stipulated 3 classes of individuals qualified to engage in legal practice: lawyers who already had qualification from abroad following formal training, persons who are in sufficiently close proximity with local lawyers to be considered sufficiently versed in law to be admitted to practice, and persons who were permitted to practice in the meantime due to lack of skilled manpower. In the case of the last two, it said that sometimes the minimum requirement was that they could read and write without any formal education. So much for that period. Consequently, the period of 1914 to 1962 saw only qualified barristers and solicitors trained in England recognized as advocates in Nigerian courts. This was still not considered sustainable as Nigeria approached independence in 1960, which led to the Legal Education Act 1962, which placed the duty of legal education on the Council of Legal Education, established by it, and the Legal Practitioners Act, which is presently being looked into for amendment. According to the former act, the training of aspiring legal practitioners will be undertaken by a Nigerian law school established by it. Under the act, the council is empowered to issue qualifying certificates to persons who have successfully completed 1 year academic year of practical training, with emphasis on procedural law at the school. The Legal Education Act will later be reenacted as Legal Education Consolidation Act 2004, Cap L10. Its tradition, now established by statute, has been that of calling to the bar persons who have completed the course of study at the Nigerian Law School. We identify the various campuses. At the call to bar, the body of benchers serves as a gatekeeper, affirming that entrants meet the educational, character, and professional requirements prescribed by law. The ceremony signifies the conferment of professional status and the assumption of ethical obligations by the new legal practitioners. It is regarded by the outsiders as where they give us oath into a cult. And I recall that when I came out after the normal tradition of the call, the launch, my father asked, "Where is your own ring?" And the question is, which ring? They said they normally give you a ring that will symbolize your introduction into that. I said there wasn't anything like that. The minimum requirement for admission into the law school is an LLB degree from a recognized Nigerian university. However, students with degrees from law faculties from foreign universities are also considered for admission on the condition that they make up the apparent deficit in knowledge of critical aspects of Nigerian law by being deployed to a recognized law faculty of a Nigerian university to study some basics about Nigerian law. In Nigeria, there are 3 ways of being legal practitioners. We have called attention to it. Second, legal practitioners are public officers are prohibited from engaging in private practice. A contentious issue in relation to this is the argument that law teachers are exempted from this prohibition and may engage in private legal practice while employed as public officers, and that law lecturers do not fall within the purview of this rule as they have been exempted by the regulated and other professions, private practice provision law lecturers, exemption number 2, order 1992. However, the Code of Conduct, which is part of the Constitution, does not make this exemption. The only concession the Code of Conduct makes is regarding farming. It raises the question of the supremacy of the Constitution. can a subsidiary instrument, which admittedly by virtue of Section 315 of the Constitution's existing law, override the supremacy of the Constitution under Section 1.3? The constitutional question is fundamental. Section 1.3 of the 1990 Constitution provides ambiguously that if any other law is inconsistent with provisions of the Constitution, this condition shall prevail, and that the other law shall, to the extent of its inconsistency, be void. The Code of Conduct is part of the Constitution 5th Schedule, and Section 318 defines Code of Conduct as including the Code of the 5th Schedule. Even if the 1992 order were constitutionally valid when made as existing law under Section 315, the subsequent constitutional entrenchment of the Code of Conduct through the 1999 Constitution raises serious questions about whether the Constitution has effectively covered the field, rendering the exemption void. Elsewhere, the Constitution prohibits persons who have previously been judicial officers from appearing before any court. This is not exhaustive of the list of disqualification. As best global practice approach, it is important to reiterate that our trainees at the various faculties of law and the Nigerian Law School must be exposed to the recent developments in law. And one of the ways to do this is for the law lecturers to have opportunity to learn the best from our courts. The current argument against allowing law lecturers to engage in private practice is doing more harm than good. Consider for a moment that our doctors are restricted to classrooms when training prospective doctors. We all know the disastrous consequences. Empirical evidence suggests that many law lecturers currently engage in limited practice through consultancy, pro bono work, or partnership with practicing firms. And this exposure demonstrably enriches classroom teaching with practical insight. There is therefore a very urgent and serious need for a rethink, ideally through a constitutional amendment that explicitly exempts law lecturers from the prohibition, or through a judicial clarification that recognizes legal education as a form of public service distinct from ordinary public office. The body of benchers cannot be a bystander to this fundamental issue, especially given its mandate to ensure that the highest professional standards with an emphasis on the profession's ethical imperative. What kind of lawyers are we unleashing on society if their teachers are only exposed to the theories in the books, both at the law faculties and the Nigerian Law School? The body of benchers must take the front seat, and this is, in our view, is a mandate beyond call to bar. The history of the body of benchers has been admirably captured in various speeches this morning, and I go to the membership. By virtue of Section 3.1 of the Legal Practitioners Act, the following are the members of the body of benchers: the Chief Justice of Nigeria and not Justice of the Supreme Court, the President of the Appeal, the Attorney General of the Federation, the presiding judges of the Court of Appeal Divisions, the Chief Judge of the Federal Capital Territory, the Chief Judge of the Federal High Court, the Chief Judges of the States of the Federation, the Attorney General of the various states of the Federation, President of the Nigerian Bar Association, Chairman of the Council of Legal Education, 30 legal practitioners nominated by the Nigerian Bar Association, and such number of persons not exceeding 10 who appear to the body of benchers to be eminent members of legal profession in Nigeria of not less than 15 years post-call standing. No doubt, this composite structure underscores the body's role as a bridge between the judiciary, the executive, legal education institutions, and the practicing bar. Its statutory foundation positions it as the guardian of entry standards and professional discipline within the legal profession. The Act also provides that the Chief Justice of the Federation shall hold office as a bencher for life. Outside this, the Act permits the body to confer life membership on any bencher, as well as set out circumstances in which a bencher may become supernumerary bencher. By its own admission, the body might and is empowered to make room for excessive, surplus, or superfluous benchers. This will perhaps explain why in 1 year, survival bencher was about 314. This appears to give the impression that from the very outset, the body was probably not conceived as exclusively functional, efficient, and pragmatic. Justifiably or not, therefore, this membership structure and number leave the indelible impression of a body designed with patronage as a key underlying purpose. From a public choice theory perspective, the persistence of life benchers and supernumerary positions, despite their contribution to regulatory efficiency, reflects institutional actors' tendency to preserve arrangements that confer prestige, benefits, even when they lack functional justification. There's a need to whittle down, in my own view, the membership of the body of benchers so that it is not only leaner, but also appears more functional and efficient. It would be logical for the body to have such a massive membership if it were responsible for the body's secretarial functions. However, it is not, and it's clear that the body of benchers has its own bureaucracy that deals with that. It must be emphasized that the call for a trimming of membership is not to underrate the essence of the quality of the membership as presently constituted. However, given the time in the provision under the consideration was enacted, the number of interests represented is not as large as it is now. In the same way, without prejudice to the quality of members currently overseeing the affairs of the body of benchers, it must be emphasized that the body is essentially a policy-making body. To that extent, the membership cannot be justified in the light of the current realities. My humble view. By virtue of Section 8, the quorum of meetings of the body is 10. That is exceedingly low for a body that could number over 300. In Nigerian company law, the quorum for meetings of board of directors is 1/3 of the directors when there are more than 6 directors and 2 when there are fewer than 3. Under the Constitution, the quorum for meetings of the federal and state executive body is established. The aforesaid quorum stipulated for meetings of body members is essentially 1/3 of the members. This further underscores that not many members of the body of benchers are expected to participate. The prescribed quorum will appear to be quite anticipatory of the redundancy of most of its membership. That is troubling for a body that could number over 300 at any particular time. In my humble view, the essence of this number is to ensure a very wide participation. But with the quorum of 10 members, it is clear that the essence is defeated. I, however, assume that over time, the body of bencher has administratively improved this quorum, but has not made it available to members of the public. At the time the Legal Practitioners Act was enacted in 1962 and the amendment, the concept of 6 geopolitical zones had not been established in Nigeria. This concept may need to be incorporated in the membership structure of the body of bencher and could prove very helpful in streamlining the body's membership. If the thinking is to adopt the structure of an agency for the body of bencher, it is enough that Chief Justice of Federation is a member. There appears to be no necessity for all the other justices of the Supreme Court to be members of the body, although 1 or 2 may be added. In the same vein, there appears to be no need, in my humble view, for the presiding justices of the divisions of the Court of Appeal to be members when the president of the Court of Appeal is a member. 1 chief judge from each of the 6 geopolitical zones should be sufficient instead of all the 36. Similarly, in my view, 1 state attorney general from each of the should suffice rather than all the 36 of them. The appointment of the 6 state attorney generals should be done in a way contemplating which states are not represented in the appointment of the state chief judges. It's probably time to reconsider the idea of life and superiority members, while the idea of the NBA nominating 30 legal practitioners and body of benchers nominating a maximum of 10 persons who appear to be eminent members of the legal profession of Nigeria deserve a second look in terms of the numbers to be so considered. If the body of benchers found the idea of life benchers imperative, then there may be a need to review the criteria for the appointment of life membership. If the body needs to benefit from the best technical expertise, it can employ consultants as other regular agents. The powers and functions of the body of benchers, I've taken the liberty to list out the functions as specified in sections 3, 11, and 12 of the Act. The pressing issues concern the relationship between these functions on the one hand and the membership and structure of the body on the other hand. In other words, which of these statutory functions necessitate over 300 benchers to carry out? None of them. The same observation applies to hold true of the powers granted for managing succession elections of the National Executive Committee of the Nigerian Bar Association under Section 2 and 3 of the LPA. That is on the one hand. On the other hand, there is the rather silent function that does not feature in the statute, that of sponsoring prospective legal practitioners in Nigerian law school for enrollment at the bar. The Act is silent on this function. It does not feature in Section 3.1 of the Act, but it is real and is taken that in practice, one of the functions of benchers is sponsorship of aspirants to the Nigerian bar. It's a requirement for call to the bar. This lecturer was, like every legal practitioner practicing in Nigeria, sponsored by 2 members of the body of benchers as a precondition. And I thank the body of benchers for sponsoring me. When employed as a bar means any of the following: to pay the cost of a particular event, program as a way of advertising, to arrange for official to take place, to agree to give money for a charity if they complete a particular task, to support by paying for their training or education, to introduce a proposal for a new law. In some other dictionary, the expression simply means one who assumes responsibility for some other person or thing. In one sense or another, none of these meanings fits into the context in which a bencher is to sponsor an aspiring legal practitioner. What is clear is that whether it is in terms of a person presenting a candidate for baptism or confirmation, where there is an assumption of responsibility for the person's religious education or spiritual welfare, or in the sphere of immigration laws in the United States, where sponsoring an immigrant in the United States comes with responsibility, there is usually a change in the status of the sponsor. In the former, it is merely a change in responsibility, but in the latter, it is clearly a case of liability. According to the authority, when you sponsor an immigrant, legal responsibility for financially supporting the person. The provisions has been provided. In such cases, the law also imposes a duty on sponsors to inform the authorities of their current address and to file a notice of change of address when there is a change. Failing to report a new address is a violation that can result in civil fines. The Supreme Court has also underlined this change in the duties of a sponsor. In Faleke and Independent National Electoral Commission, the Supreme Court held that by virtue of Section 221 of the Constitution and Section 37(1) of the Electoral Act, the All Progressive Congress, being the party that sponsored the appellant and Prince Abubakar Audu for an election and being the party which would be declared the winner in the event of their success at the polls, the said APC had a legal interest in the votes cast at the election and was entitled to substitute a candidate of his choice election to conclusion, whereas candidate had died in the course of election. Here, there's a change not only in terms of responsibility, but also in benefits. The question starts to mount. Why then does practice permit a bencher to sponsor someone? This sponsorship. What does it lose if the sponsored person misbehaves? It does not lose any benefit. It does not assume any responsibility in any way, because unless perhaps he or she is a member of the disciplinary committee, it is never even brought to his attention, and many times he will see the name and not even remember that he was the sponsor. These are on the one hand. On the other hand, from the membership of the disciplinary committee as prescribed under Section 10(2) of the Legal Practitioners Act, it is clear that invariably a legal practitioner charged with misconduct might be tried by a committee that includes his sponsors. By virtue of Section 10(2) of the Act, the committee membership consists of the Attorney General of the Federation, the Attorneys General of the states, 12 legal practitioners of laws less than 10 years standing, appointed by the benchers on the nomination of the association. Why does one sponsor someone only to have them come back to be on a panel that tries them for some misconduct? What guarantees for of nemo judex in causa astra? Just remembering that the basis on which trials are set aside for a lack of fairness is not actual bias, but the likelihood of it. This raises the serious constitutional questions under Section 32 of the 1990 Constitution, which guarantees fair hearing. The likelihood of bias, whether real or perceived, when a sponsor sits in judgment over a sponsored person, undermines public confidence in disciplinary proceedings. Having now demonstrated some possible flaws in the existing situation in terms of provision, membership functions and powers, as well as changing narratives and expectations, it is apposite to examine what happens in other jurisdictions and to determine how best we can factor them into our current position. This may also be important for adaptability in our peculiar context. This is more so when the other jurisdictions to be considered share some peculiarities with us as a nation. Thus, the cross-country analysis. There's need to examine the regulations of legal practitioner in other jurisdictions to determine what lessons, if any, Nigeria can learn to improve regulation of legal practice. A study of England and Wales reveals that legal practice or legal service as it's prescribed in those jurisdictions is regulated by Legal Services Act 2007. The overall regulatory body for the entire structure of legal services in England and Wales is Legal Services Board, established pursuant to Section Legal Services Act 2007. The board has only 8 ordinary members, comprising chair and other members. The chief executive also sits on the board. Significantly, Legal Services Act explicitly requires that the board's membership include lay persons, that is, non-lawyers. This requirement reflects a fundamental principle of modern professional regulation, that the public interest is best served when regulatory bodies include voices from outside the profession being regulated. Reducing the risk of regulatory capture, this also underscores the principle of inclusivity. Outside this, the Act segments legal services into several parts: reserved legal activities such as advocacy, soliciting, litigation, probate, administration of wills, conveyancing, that only authorized individual practitioners or firms can perform. And it creates different dedicated bodies for their regulation. Solicitor services in England are, for instance, regulated an administrative staff of 102 members of staff led by Director General and a senior leadership team of 8. This structure will appear to be a more conventionally structured body than the body of benchers. If it is structured in this way, then of necessity, questions of independence and funding will be asked. Although given the current structure, the question of independence is no starter, the current structure allows for the Chief Justice of Nigeria and all judges of the Supreme Court as benchers, and those I've listed. It is noteworthy that National Judicial Council, which proposes the appointment of these justices, is a federal executive body by virtue of their appointments as President of the Federal Republic of Nigeria before confirmation by Senate. It must be noted that the body of benchers today is essentially a federal government body funded from annual appropriations. In the not too distant future, the independence of the body of benchers will be of concern. In legal ways, it appears that the legal services body is funded by legal profession through levies imposed on the approved regulators, which cover the full cost of the legal, not correct with the choice of Ghana, which is literally next door to Nigeria and perhaps closer in cultural antecedent. In India, a country with a population of 1.46 billion as of 2023 and over 2 million registered advocates as of 2025. Legal profession is generally regulated by the Advocates Act 1991, which established the Bar Council of India and State Bar Councils. To apprehend dichotomy between the functions of the Bar Council of India on the one hand, those of the State Bar Councils on the other, it is imperative to examine them. The Advocates Act has carefully divided functions between the Bar Council of India and the State Bar Councils. The key functions of the State Bar Council under Section 3 of the Act are as provided, and Section 7.1 provides for the functions of the Bar Council of India. Section 7.1 F, G, and I are very fundamental because they establish the Bar Council of India as a overriding regulatory body. India's two-tier system addresses a challenge Nigeria also faces, regulating a profession across a vast, diverse country with significant regional variations. Nigeria's unitary structure of the body of benchers concentrates all power at the center. Consideration might be given to whether Nigeria needs zonal or state level benchers bodies for initial admissions screening, with the national body retaining appellate and standard setting functions. This will bring regulation closer to the people and reduce the current over-centralization. As for adopting the Indian model in Nigeria, considerations against it include that Nigeria's population, landmass, and number of legal practitioners are significantly lower than India. In addition, there has been a significant technological revolution, particularly in information and communication technology, such that transactions are conducted at the speed of light, which tends to make the 1961 India model less imperative. The functions of the Bar Council of India and the State Bar Councils are generally combined in the body of benchers in Nigeria, although Bar Council of India performs more or less the same statutory functions of the body of benchers. The council consists of 18 members, including the Attorney General and Solicitor General of India's ex-official members and representatives elected from each state bar council, one member elected for a 5-year term, with the chairman and vice chairman elected every 2 years from within the council. The legal profession in Ghana, a country with 35 million people and 8,000 lawyers, is regulated by the Ghana Legal Council, which is central regulatory authority. Similarly, there are conferred functions on the Ghana Legal Council that are in effect the same as those performed by the 10 to 15 members. It is chaired by the Chief Justice, while its membership includes Supreme Court justices, the Attorney General, Director of Legal Education, the President, Vice President, and Secretary of the Ghana Bar Association, as well as representative of the law faculty. Judicial Secretary heads a bureaucracy that works with Ghana Legal Council. There's no evidence at all that members of the Ghana Legal Council sponsor prospective legal practitioners into the legal profession. Only in the case of successful completion of the course of study at Ghana School of Law will such prospective pupils obtain forms to be filled by the senior colleague who would have practice of for not less than 7 years, but is not necessarily a member of the Ghana Legal Council, and who will be their mentor. Upon completion of the pupillage, the senior fills a form declaring the same, and the form is sent to the Ghana Legal Council. Members of the Ghana Legal Council do not sponsor prospective lawyers for practice. A critical appraisal of the three jurisdictions examined will clearly demonstrate that there's a need to trim down the present membership of the body of benchers, to review the funding model, to assess how technology can be adequately deployed, to examine the sponsorship model, and other related. One thing that is clear is that body of benchers must play a more critical role and fulfill the functions and powers assigned to it by the Enabling Act. There must be some introspection on how the Nigerian community can see the body of bencher beyond the present ceremonial call to bar and have more impactful effect on society. In sum, the following is a summary, the recommendation arising out of this study. One, the body of bencher should be structured to take the shape of a conventional agency. Two, its membership must be reduced along the lines discussed in this paper. Three, the idea of 6 geopolitical zones must be introduced into the membership to help streamline abolition of live membership, abolition of primary membership. 2 laws on its membership must be created for the representative of the deans of recognized law faculties in Nigeria, and abrogation of the principle of sponsorship. 2 laws should be given to the National Law Teachers Association, as comprises of law teachers from different faculties across country. The membership of LPDC should be made to constitute lawyers alone, especially given the fact that the National Judicial Council, which oversees the discipline of judiciary, is constituted by judges. Following the specific recommendations above, general recommendations are made regarding the continuing relevance of the body of benchers. The body of benchers must retain relevance to preserve the ethical identity, dignity, and professional values of the Nigerian legal profession. Its relevance sustains the credibility of the call to bar and provides a non-partisan moral anchor that bonds the bench, the bar, and the public. Without a strong and respected body of benchers, public confidence in legal practitioners and the justice system is at risk of serious erosion. Traditionally perceived legal largely through the prism of the call to bar ceremony, the must evolve beyond predominantly ceremonial institutions to remain relevant in a changing legal environment. Its future relevance depends on assuming a stronger regulatory and ethical leadership role, with a clearer institutional voice on professional standards and a more active, transparent oversight of entry into the legal profession, by articulating a clear identity that extends beyond rituals and symbolism. The body of benchers can reaffirm its central place in safeguarding integrity of the Nigerian bar. And I listened to the executive chairman of EFCC when he came on this podium to call attention to some of these issues. As we know, a number of the members are also is a guest. Closely linked to this evolution is the need for an expanded role in legal ethics and discipline. Rising incidents of professional misconduct and sharp practices and declining public confidence in lawyers underscore the necessity of a credible ethical anchor within the profession. The body of bencher is well positioned to fulfill this committee, development of clear ethical guidelines, and a shift towards preventive ethics that emphasize education, mentoring, and early intervention rather than punishment alone. The increasing complexity of legal practice, driven by technology, internationalization, arbitrary and multi-door processes, and artificial intelligence also demands greater involvement by the body of bencher in shaping legal education and professional training standards. Its future relevance will be enhanced by contributing to curriculum reform at the Nigerian Law School, setting minimum ethical and professional benchmark for aspiring lawyers, and reinforcing the importance of character, integrity, and professionalism alongside academic competence. In this way, the body of benchers can influence not only who enters the profession, the kind of lawyers they become, the kind of legal profession we have, and the kind of legal practice we envisage. Finally, the authority to determine admission to the bar places the body of bencher at the heart of professional gatekeeping, a role that will increasingly attract public scrutiny and demands for accountability. I think it is time for the body of benchers to come out strong and clearly on the number of students to be called to the bar on an annual basis. Beyond gatekeeping, the body of benchers must reclaim moral leadership within the profession, speaking out on threats to judicial independence, providing principled guidance during national legal crisis, and acting as a stabilizing institution above sectarian and factional bar politics. Through institutional reform, modernization, and constructive engagement with other legal bodies, the body of benchers can remain a respected guardian of professional ethics and standards of Nigeria's legal system. Other recommendations that include that greater public and professional awareness be created about the body's broader mandate, that is, disciplinary processes be further strengthened through institutional reforms and continuous engagement with emerging legal challenges. And I believe that the unveiling of the directions of the LPDC is in the right direction and may assist in ensuring that the mandate of the body is performed. While the ceremonial functions are important, disciplinary and ethical oversight roles are even more critical to the profession's sustainability. In recent years, the body of benchers has undertaken institutional reforms to reposition itself as a proactive regulator rather than a largely ceremonial institution. This kind of discourse is part of the fundamentals of repositioning of the body. There is a need to strengthen the FPDC, improve disciplinary processes, adopt technology for case management, and enhance collaboration with the Nigerian Bar Association and judicial institutions. It is also important to emphasize that there is a need for an end-to-end approach to addressing ethical issues, as the input ultimately determines the outcome. A sponsor of a candidate must assume greater responsibility for the candidate and have more than a passing interest in the candidate. There's also a growing emphasis on public engagement and transparency, particularly in disciplinary proceedings, to demonstrate accountability and reinforce trust in the legal profession. These efforts reflects a conscious attempt to align the body's operations with global best practices in professional regulation. Looking ahead, the relevance of the body of benchers is likely to increase as legal practice becomes more complex, technologically driven, and globally interconnected. Issues such as transborder practice, alternative district resolution, artificial intelligence legal services, and evolving client expectations require robust ethical and regulatory sponsors. The body of benchers is well positioned to shape these responses by updating ethical standards, enhancing disciplinary mechanisms, and fostering collaboration with international legal bodies. Its future impact will depend largely on restructuring it along the lines proposed in this part to make it more purpose and result-oriented in performance and perception, as well as on its ability to remain adaptive, transparent, and responsible to the changing dynamics of legal practice. Once again, I thank the body of benchers for giving me the opportunity to share my thoughts on this part.
Please, another round of applause for our keynote speaker. My noble lords, what you have just witnessed in 30 minutes, I witnessed it for 5 years at the university. Thank you so much, Prof. Um, I saw when Professor Abubole was speaking that some of our distinguished benchers, some people were shaking heads, right? Um, because, and that was why he was invited by the committee that came up with this annual lecture. Truth must be told, and most times it might have to be told from the outside. In a deeply reflective and thought-provoking keynote, Professor Egbewole SAN has invited us to reimagine the body of benchers, not merely as a ceremonial gatekeeper of the call to bear, but as the central ethical and regulatory anchor of the Nigerian legal profession. The keynote interrogates whether the current structure of the body, particularly its expansive membership, life benchers, supernumerary positions, and sponsorship model, aligns with what applies in other parts of the world. And he drew lessons from United Kingdom, India, and Ghana to make his point. At its heart, the paper calls for a body of benchers that goes truly beyond ceremony, one that asserts moral leadership, strengthens the disciplinary process, embraces technology, engages more transparently with the public, and actively shapes the future of legal education and ethics in Nigeria. My noble lords, distinguished benchers, the message is clear. If the body of benchers must remain the guardian of this profession's dignity, then reform is not optional. it is imperative. Once again, thank you, Professor, for challenging us to think beyond tradition and towards transformation. Please, another round of applause for him. And the model of this annual lecture would involve some we have a very rich faculty of panelists. But before I invite them to take their seats here, may I respectfully um, apologize for omitting when I was recognizing the Justice of the Supreme Court, my Lord Honorable Justice Mo Asaimo Ibrahim Adumi, Justice of the Supreme Court. My Lord, you're most welcome. I appeared so much before my Lord at the Court of Appeal Benin that I thought that I was seeing my Lord in court again. My Lord, I apologize for that. We also have, of course, the former chairman of the Board of Benchers, Ashiwaju Adegboyega Solomon Awomolo, Senior Advocate of Nigeria, who inaugurated this lecture series. Daddy, you're most welcome. I also have seen the former Minister of Justice, Mr. Mohamed Adoke, Senior Advocate of Nigeria. You're most welcome, sir. We also have the former NBA President, Mr. Abi Mahmoud, Senior Advocate of Nigeria. You're almost, Mr. President, it's been a while. Good to see you again, sir. And of course, the tallest member of the INABA, from immediate past president of the Nigerian Bar Association, Mr. YC Mikiel, Senior Advocate of Nigeria. OON, you're most welcome, sir. Thank you. Like I said, we have a rich faculty of panelists that will be joining the keynote speaker, and I have the honor of inviting my Lord Honorable Justice Chidebere Unwauma Uwa to this part of the podium. My Lord, please. Justice of the Supreme Court, live bencher. We also have Mr. R.A. Lawal Rabana, Senior Advocate of Nigeria, live bencher, former General Secretary of the Nigerian Bar Association, as a panelist at this lecture. You're most welcome, sir. Thank you, sir. Very quickly, we also have the chairman of the ICPC, Dr. Musa Adamu Aliyu, Senior Advocate of Nigeria. And last but not the least, she can be the least. She's a teacher. Dr. Olugbemisola Titilayomi Udushote, the Director General of the Nigerian Law School. You're most welcome, ma'am. We also recognize the presence of the Director General of Legal Aid Council of Nigeria, who is represented by the Director of Criminal Litigation Department of the Legal Aid Council, Mr. Okoigbu Egenti Kingsley. You're most welcome, wherever you're seated. Thank you. And so very quickly, our first panelist today is my Lord Honorable Justice Chidebere Unwauma Uwa.
Yeah.
Our first panelist, my Lord, embodies the full arc of judicial service from the magistracy to the apex court. My Lord was called to the bar in 1983 and has served across multiple tiers of the judiciary before our elevation to the Supreme Court of Nigeria in 2024. Our Lordship's extensive experience from trial courts to the Court of Appeal and now the Supreme Court of Nigeria gives our unique vantage point on professional discipline, judicial ethics, and the real life consequences of the standards set at entry into the profession. As we reflect on the body of benchers beyond the call to bear, our Lordship's judicial journey speaks to the long term institutional impact of those standards on justice delivery itself. We are privileged now to hear from our Lordship as she speaks to the paper just delivered by Professor Igbawale, Senior Advocate of Nigeria. My Lord, please.
Yes, my lord. Yes. Okay. My lord, the Chief Justice of Nigeria. Yes, sorry. No, here. Down here. Where here? It's going on. Okay. My lord, the Honorable Chief Justice of Nigeria and Chairman of the occasion,
With your permission, I will stand on the existing protocol. It's indeed a privilege to have been nominated as a panelist. The topic is very apt and a very burning issue because it seems like after the call, from the call, it's all ceremonial. The robing, the pomp and pageantry, the students themselves, and all. The question is, what happens the day after? What happens to the wig and the gown joyfully put on the day of call? Then what role do we play? Have we played in the past, present, and hopefully in the future to ensure that the newly called or the aspirants before the call will look at post-call because the lead lecturer, Professor Bewole, did a very good job and covered all fields. We didn't expect any less from him. I've known him for a very long time, even before he became the VC University of Ilorin. And we know the standard of that university, not limited to law as well, generally. It's one university I know that doesn't join in all the strikes and what. I'm not saying it's right or wrong or whatever, but very focused. Yes, they will benefit at the end and all, and that's it. So he covered all fields. So we'll look at what have we done or what have we been doing to ensure that the newly called to the bar stick to what we want the legal profession to be. Because it's from there that we get the magistrates, the practitioners, the senior advocates, those who like the judiciary or judicial work will continue. When it comes to sponsorship, the learned prof said the sponsorship could be done away with, like in other countries. Give these examples of India, they don't have it. Ghana has it, but post-call. We, as body of benchers here, live and regular members, what do we do when we sign those forms? When we sponsor them? We only sign. And I'm sorry to say this, a lot of benchers don't even see the students. The secretaries collect their forms, they sign and stamp and pass them back on. No interview, no questioning, not even examining their mode of dressing. I've had to send one or two away in the past and still recall them and caution them, even coming to the Supreme Court or in the Court of Appeal then, to have their form signed, improperly dressed, not well groomed. The females are something else. They're the worst. I'm sorry to say that too. And then the men, they will not be formally dressed. Now, if you cannot be properly dressed to take your form to a bencher to sign, how would you do if you do go into legal practice, post-call, appear in court? Till date, we're still correcting dressing in court. We're still correcting carriage, comportment, bad language, etc. Going through the paper, I made some jottings here and there. The lecturer, prof, said we should reduce the number to be called to the bar. That cannot start at the Nigerian Law School level, at the Council of Legal Education. No, that should go back to the admissions, the universities. We're churning out lawyers every day, both state, federal, and private universities. And they over-admit, irrespective of what NUC has given them to limit the admissions to. The 10,000 that we called last year, even after that call, we had a whole lot of backlogs. I do know because people reach out to us. Oh, I graduated 2 years ago. I haven't been able to go to law school. Haven't been able to do this. So it has to be checked. Prof, note from your admissions before we get to the Council of Legal Education. And then I feel the body of benches too should work closely with the NBA. If we were to regulate or be the watchdog of what legal practitioners should do or should look like, we should work closely with the Council of Legal Education, work closely with the MBA. I don't think the MBA has been doing much in respect of mentoring, not just mentoring, ethics, integrity. We're having too many complaints here and there, too many problems involving lawyers, young and old. In the holy books, we advocate teaching children, encouraging them in their faith as young people so that they grow with it. And we believe they will not depart from it if you have grown in such areas. So, and from the call is a transition to a different life altogether, because as students, it's all theory, theory, theory. It's not practical, it's just theory. You're taught do's and don'ts and this. What have we done and what are we doing to help the newly called to the bar from the day of call to transit now into legal practice and keeping to the ethics of the profession? Integrity is so important. Even in court, you say, I speak from the bar. I'm speaking as a lawyer. All the speeches and all the past, are you living up to the expectations? So we should guard the newly called, post-call, or in cause of their call, so that the rule of law will be maintained, and that will also help us at this end as judicial officers to deliver justice in a better way. And then this mentorship, Prof advocated reducing the number of benches. I don't think it should be reduced. Even by the attendance of this lecture, how many are we here? Prof came up with, I think, 314 live benchers, 140 something benchers, 314, about 460 something, all together, almost 500,000. How many are in attendance today? On the other hand, I would feel we should even increase the number. And this is the reason. How does this number we have, how do we mentor the thousands, over 10,000 every year being called to the bar? It's difficult for them to reach us, even to sign the form ordinarily signing the form. How do we mentor them? I think the mentorship should not be limited to the committee of the body of benchers on mentoring. How far can they go? How can they reach the newly called to the bar post call? I think each and every member of the body should endeavor to be a practical mentor. Make yourselves available. Everybody is busy. We are all very busy, but sometimes make out time, even if you have to schedule it to a particular day, particular time, and all. Most of the students, from my experience of the dinners, where we had to now step down to speak to them for about 5-10 minutes before leaving at the end of the dinners, some have no clue what it's all about, what it entails to be called to the bar, what to even do with their degrees, the LLB, LLM, or BL. They don't know. They have no clue. Most of them, nobody has chose to read law because their mother, their father, or their law or whatever they encouraged to do it. They had no clue. Personally, after these dinners, I've had many of them come back to chambers to ask more questions and to say, oh, after you spoke to us, I think I will now do this, I will do this, which they had no idea of before then. And then Prof's suggestion to, let me deviate a bit, yes. And then how do we impact also knowledge to these people if we're not interacting with them? The law school dinners, how many of us attend? Sometimes in some law schools, you just have 2 benchers in attendance, 3 in attendance. Abuja and Lagos normally have the highest numbers. How many attend? I know of benches who had to make effort. I know the chairmen do that just to make up the numbers and to enable the students see them, see their chairman, see life benchers, some senior advocates, judges, chief judges, attorney general of the federation, AGF, and other attorney general. They go round to ensure that these students see them, ask questions, and all. If we have poor attendance in Abuja, poor attendance in Lagos, heavily populated by benchers, imagine what used to happen in Yola. I was there for 4 years. 2, 3. The most we were ever, and the same people all the time. My Lord Justice Bansi and a few of us. 3, 4. 2. So if we decentralize, as suggested in the paper, I can assure you, law school dinners will take place with no bencher present. Coming to the call as well, with our present number, how many of us are committed enough to attend at least one session of the call to bar ceremonies? At least one. Forgetting the cost and the inconvenience of having to come to Abuja and all. So reducing the number, obviously, will not be the solution. If anything, I think the number should be increased. We should include the Grand Cadis because they're a specialized court. We should also consider including President's Customary Court of Appeal. I've always wondered why they're not included. Now, the suggestion was that the Honorable the Chief Justice of Nigeria should represent judiciary as a whole and be the representative of all the justices of the Supreme Court. How is that practical? The Chief Justice of Nigeria is one person, very heavy docket. We're talking of sitting, administration, international, local conferences, body of this, so many bodies, NGSC, FGSC. So if His Lordship with NGSC, FGSC meetings, all sorts, both home and abroad, is it practical for His Lordship to attend all the meetings? Same goes with the President Court of Appeal to represent 20 divisions of the court. Is it possible? I don't think it is. On the other hand, at this point, I think I will also make a suggestion of having just the Honorable President Court of Appeal to represent Court of Appeal will not be adequate. Already, I have a personal opinion that we're deficient. We need more members and we have to be more committed. Not just be, oh, I'm a live bencher, so what am I going there again for? Why are you a live bencher? When the students have never seen a Justice of Supreme Court, an Attorney General, a senior advocate, some have not on one-to-one. They only read about us and see us in the law reports. We have to be more committed if we want to make a difference And then the ethics, the ethical aspect, I think, is what I picked as the most important bit of it. We have over relaxed over the ethics of the profession. It's something we should adopt as a lifestyle. You know, your relationship with the bench when you appear before us, and then amongst your colleagues and with your clients. You must have that in mind always. It's a lifestyle I think we should adopt to live up to expectations so that we don't disappoint those that we want to mentor us. Will they mentor all sorts of things they see on television that even lawyers will be granting interviews and deciding cases on the screens of the television without waiting for the courts to take their decision? I think the bar, the NBA president, well, the bar here, they should do a bit more than they're doing. I don't think the present bar, I don't know what, well, those days in bar meetings and all these were um, discussed. So post call conduct and ethics, it should reflect what we want, what we expect, not just to talk about it and we do nothing about it. We have to be more proactive. Yes. And then, yes, also we have to do more working together with the Council of Legal Education, the Nigerian Law School, the various branches. I don't think we exhibit any form of relationship outside this meeting place. We ought to be more active. The chairman, my lord, the chairman, please. We ought to be able to make input as to the continuous learning. Learning, not just limited to pass exam, get called to bar, and that is it. It shouldn't. And we also have to have in mind the changing trends globally, fintech, AI, etc., and all. And then not limit ourselves to the usual analog. Yes. ADR, etc., to be encouraged. So the chairman is here, NBA, you have to do more at your level because they will start there before they come up. Mhm. And then at the end of it all, even from now, can we say we have done well amongst ourselves in promoting better ethics? It's not just about dressing and being upright on your own and all. How do you influence those around you, your friends, your colleagues, and the members of the bar, most especially, and the younger generation? Yeah, so I stress on integrity because when our names come up here and there, judicial officers or members of the bar who are in practice, then what does that tell the younger generation about us? Of course, they'll be disappointed and all. So we have to work on that. The role integrity cannot be overemphasized. That's also guides us in ensuring also that we deliver justice at our end as judicial officers. And at this point too, I know my time is up. I'd like to also mention that I'm a life bencher, so don't say I'm talking for myself. With my colleagues, I feel having gone that far and reached the apex court, they should be considered to be made life benchers. It should be considered by virtue of having, of being in the Supreme Court. Sometimes attendance is extremely difficult and all. But of course, we are here. We have been attending when we are not sitting, so that if it could be considered for live benchership. And then scrapping it, if it is scrapped, the live bencher position is scrapped by, as suggested by Prof. It's not just, it wasn't awarded in the past. You earned it by attendance, at least 50% attendance, call to bar, meetings, and the dinners. If it's abolished, what happens to the existing live benchers? So they will delete it and be writing bencher. What happens if we do away with it? Yes. The one of my colleagues was a suggestion because a lot of them a lot of my colleagues have also been agitating and worried. Like some are not here now, on other days, they're sitting. By the time we rise, that happens too with the chief judges and all. The chief judges, the heads of courts, yes, the heads of courts are affected by that as well. But I can only speak for my colleagues. Thank you very much.
Thank you
Yes.
so much, my lord.
Thank you very much, and thank you for the opportunity.
Thank you so much,
Yes,
my
to
lord.
air myself a little bit. Thank you. It's not over yet, though.
It's not over, my lord. It's not over. Thank you so much, my lord, for that very practical insight. I'm sure we all are aware that the chairman of this occasion is my lord, the Honorable the Chief Justice of Nigeria. And my lord has ordered, it's an order actually, not a direction this time, it's an order that all panelists are to spend not less than 10 minutes to make their contributions to the lead paper. Not more than 10 minutes. Not more than 10 minutes to share their insights on the paper ably delivered by Professor Wahab Iqbal said. Thank you. As the call pleases, my lord. Thank you, my lord. Um, and so if my lord had said that the MBA should be involved, then there is no better person to share an insight as to how the MBA could be involved than a former general secretary of the Nigerian Bar Association himself. I'm talking about no other person than the second panelist, Mr. Rafiu Adeyanju Lawal Rabana SAN, who also happens to he has served as a member of the Legal Practitioners Disciplinary Committee. He chaired the Ethics and Compliance Committee for 6 years, and he now leads the Body of Benchers Committee on Projects and Infrastructural Development. Please kindly make him welcome. Then also, I lost 10 minutes.
Sorry,
Oh,
give me. Well, my lord, I will speak faster when I'm standing. So I will make sure I'm within the time frame. And let me also start by adopting the practice of my laws of the appellate court, that I've had the privilege of going through the paper delivered by the keynote speaker, Professor Wahab Egbewole. And on that note, I have categorized his paper into two. The first element is that most of his suggestions and recommendations are matters that will require reforms, from membership to scrapping of sponsorship, the structure of the body of benchers. These are all issues that have to do with reform. And I just hope that at the appropriate time, we may have the opportunity to look at it when there's a need to reform. Now, there is an aspect of the lecture which I will dwell on in practical terms. That is where he said, and which I agree with, while its ceremonial functions are important, its disciplinary and ethical oversight role are even more critical to the profession's sustainability. That means considering these two key elements, discipline, ethical values. And let me start with the ethical values. And I think the body of benchers, with due respect, is lacking in this area. We are popularly known in Nigeria for wearing our wig, ceremonial gown to attend call to bar or to attend the law school dinner. If you ask any aspirant to the bar, he will just tell you, we come to law school to have dinner with them and nothing more. But the body of benchers, we should look beyond that. In view of what is happening in present day Nigeria, unless the body becomes very proactive, we will find out that there will be no profession for us to protect or to promote. And I'll go this way. Starting with our own meetings. The meetings of the body of benchers, with due respect and not with reference to any particular chairman, we all met it like that. Our meetings are very boring. It's not dynamic. We come here, it's the same agenda, chairman speech, going through minutes, reports of committees, and the next thing matters arising an adjournment. We don't really identify problems that is facing the legal profession with intention to address them squarely and coming up with recommendations that will address such problems. And I'll just give you some few examples. Now let us look at the use of social media. The use of social media now is a trend that is doing more damage to the legal profession. We read, we watch what lawyers, litigants, and people that call themselves public commentators say about the legal profession, say about judges, say about judgments, and at times we just laugh and ignore them. But they are gradually destroying the legal profession. And I think that these are some of the issues that beyond the call to bar, that the body of benchers should also be interested in. How do we stop this trend of the use of the social media to definitely destroy the legal profession? It's on the increase. And I think this is an area that the body of benchers should, at times during meetings, devote a session. Let us discuss it. How do we address it? How do we sanction lawyers who are engaged in this kind of practice? We talk of the abuse of the principle of sub judice. It's on the increase. And lawyers are the culprits. What are we doing about them? We open the TV every morning and see people who will go there and be talking about live cases, discussing it, giving their own conclusions with intention to bias the public or with intention to run down the judges who are trying such cases. These are issues that should also bother the body of benchers, because if we don't protect these basic principles that has earned the profession the respect and the fear of the public, there will be nothing left here again. But when they know that there are sanctions, that when you lawyer wake up and go to the television or address the press under the guise of freedom of press, it's totally wrong. And I think this is the time for the body of benchers to be very, very proactive in addressing some of these issues. Not to talk about post-judgment comments. Yes, people are entitled to comment on judgment, but not to the extent of virtually going to abuse judges or justices for delivering one judgment or the other, at times descending on the lawyers who are also involved in such cases. You know, these are things that should concern us. When we came into this profession, we never met it that way. You'll be so scared to comment on cases pending in any court, or you'll be so scared to even talk about how a judge made a pronouncement. But now it's done with impunity. So my thinking is that these are some of the issues that as body of benchers, we should be able to look into. Then dress code is so simple, but it's also destroying the profession. We don't comply with dress codes. There is an abuse of our wig and gown. What are we doing as members of this body? If you go to some of our courts, particularly in the cities, Abuja, Lagos, Port Harcourt, you see the manner in which young lady lawyers dress. You would think they are going for a fashion parade or a fashion show with their long hair, with all the ornaments, And we look at them at times, you mention to them, they will just ignore you. They work in chambers, they have principals. So it is the duty of the body of benchers. We must ensure that our dress code is complied with and respected. When you are called to the bar and we have to supervise you, we must also supervise your conduct. Not to talk of the abuse of the lawyer's dress. I have seen lawyers live, and at times senior colleagues, board the plane between Lagos and Abuja in their collar and bib. Why should that be? Why should that be? We say the economy is bad. You see young lawyers riding Okada or Keke Napep with their collar and bib. Why should that be? It won't take you 2 minutes to get to the court premises and put on your collar and bib. So there are some little issues that is destroying the respect of this profession that we should not ignore as body of benchers. We must be able to constantly look at those issues and ensure that we get back to the values and the ethics that we came into this profession with. Then engagement with the law school. Let me say that, well, beyond the screening exercise, going to dinner and maybe called to bar, we don't have enough interaction with Nigerian Law School. And I would suggest that we probably increase the number of sessions for our mentorship with the law school. I think we do it once in a quarter or once a year. That is not good enough. We should increase the number. As the bar part 1 students are coming in, the first thing they should do is have contact with the body of benchers, talk to them on the ethics and what you expect them when they are finally called to the bar. So it is not one-off session that we should have. We must be seen, be heard, and to play more active role in the molding of these students to become lawyers. Then there is an issue that I also want to address. The era of silence is golden is over. The body of benchers cannot be silent for too long. There are so many things that we need to do. We cannot stand as an independent body. Body of benchers cannot stand alone. We must engage or collaborate with NUC when it comes to drawing up curriculum for the law profession. We must collaborate with the Council of Legal Education. We must collaborate with the faculties of law. We must collaborate. We can't stand alone because as it is, the body of benchers is seen as one big body of big men and women, and we just wear our gown and parade ourselves as benchers without more. So I want to suggest that the leadership of this body should be looking at collaborating more, even with the faculties, the law faculties. There's nothing wrong with the body of benchers having a session once in a while with the deans of the various faculties. Sit down. These are the things that we expect you to teach your students, preparing them to come into this profession. So a time has come that we must, as a matter of fact, address some of these issues. Let me quote what Justice Ogunwumiju said last year in her paper. There is a substantial erosion of the core values of mutual respect between the bar and the bench, the entrenchment of which is one of the important roles with which the body of benchers is burdened. I cannot but agree with this. We ourselves, we know how lawyers denigrate the judiciary. We know what lawyers do when they lose cases. Unless, and I keep saying so, unless there are sanctions, we will continue to be treated with this impunity. And that is where the LPDC comes in. The LPDC is doing a very good job, but you should go beyond that. What we have now, if you look at most of the cases that come before them and the decisions, they are talking about stealing clients' money, conversion, breach of trust, etc. That is what the law reports we are going to launch today here is full of. But let me also tell you that there are more important issues. And I'll just give you just one instance. Abuse of judicial process. Deliberate attempts to frustrate speedy trial. undermining judicial integrity through comments are seldomly punished. We read how lawyers just make all manner of comments about the judiciary, about justices, about cases, and nothing is being done about that. So I'm saying that the LPDC or the Nigerian Bar Association should expand the organ, should expand, look critically at the rules of professional conduct. Anything that you do to undermine public confidence in the judiciary is a sanctionable offense. So let us go beyond bar issues where lawyers are charged for stealing, conversion, breach of trust. Let us now begin to look at when you file frivolous appeals, frivolous applications with intention to delay trials, when you undermine the integrity of the judiciary with reckless and careless comments. These are issues that body of benchers should take up seriously so that we have direct impact on the legal profession. By way of conclusion, let me just say that as a body, we should promote a profession that is not just pocket driven, but integrity with decorum. Pocket driven is what most of us do. I am not a saint. We take any brief as long as the pay is good. You go to court to argue anyhow as long as you can justify your pay. That is pocket driven practice. But if we want to protect the sanctity of this profession, then we must also look at the dignity, the integrity, and the decorum that is expected of us. On this note, I say thank you for the opportunity.
Thank you so much, Leonard Salt, for your insights and for being very practical in your analysis as to what more the body of benchers can do to be that to continue to occupy that very special space that it does in our profession. Our next panelist brings a perspective from the public sector and in terms of accountability and anti-corruption enforcement. Dr. Musa Adamu Aliju was called to the bar in 2004, and he was Attorney General of Jigawa State, and he now serves as its chairman.
The chairman of the occasion, my lord, the former Chief Justice of Nigeria and the chairman of Body of Benchers, my lord Justice Olukayode Ariona, GCON, all other distinguished personalities, good afternoon. It is really a pleasure for me to stand before this distinguished body. And also, my lord, with your kind permission, I want to acknowledge Hajia Fatima Kwaku because she is one person that really inspired me because she is always keen to help young lawyers and also in practice, and also we have been learning from her, most especially those of us from Kanuba. I have read the paper of Professor, our teacher, and I agree with some of the things he raised there because the paper of Professor is professorial really, and he has raised academic issues. So from my own perspective, I want to talk a little slightly different from him. From my own angle, I want to speak as a former insider, as a member of Body of Benchers from 2019 to 2023, while I was Attorney General, and now as an outsider. And also, I'm a member of Generation X, who understand the thinking of millennials and Gen Zs. We need to understand how this generation think. So that is why, in my view, Body of Benchers is to move beyond ceremonial function to call to the bar. It must pay much attention to two things. One, mentoring, and two, sensitization. Why I say so is that as somebody who is working in anti-corruption realm, I understand that sanction is not the only measure to contain corruption. A lot of people, when you read in the history, you find that there are many countries where they even have had capital punishment for corruption. But up to now, corruption is happening. That is why we need preventive measure. And the preventive measure, in my view, is the issue of mentoring and also sensitization, most especially in one area which is disturbing within the legal profession, which is the issue of misappropriation of clients' money. Now, I don't want to go to the composition of body of benchers. I will talk first about the issue of mentoring. I want to go practical. When I was doing my attachment as a law school student, I observed some of the law firms I was going there where my friends were doing that. To be candid, I was not impressed. In fact, I had no inkling of going into practice because of what I saw. I was not keen about it. But when I was doing my NYSC, the law firm which I did my NYSC, it was the principal who first inspired me. Very hardworking, honest man, well organized. Most of his clients are not well to do, but he served them diligently. Most of the times I was sleeping. He would wake me up. Ali, what are you doing? One day you will, if you do not learn this thing now, one day you will tell me that you will regret it. And one thing he put in me is that read. Please read and read. Anything anybody tells you, read it, you can make more sense out of it. This is the first mentoring I got from him. And subsequently, I worked under 3 different principals after the first one. All of them, I learned one thing from them: patience. I'm not a patient person, but they forced me to be patient because of how they were behaving. I learned things from them. And also, when they give you assignment, you must do it within time. These are some of the things that the mentorship, the senior lawyers can mentor, and the body of benches is the place whereby all the categories of segment of legal profession are within the body of benches, so that the lawyers should be made to understand, especially the younger ones, that you need to learn this thing. You need to be patient. And also there is need for body of benches to come up with a kind of a program of success story, where the mentees and the mentors can talk to the young lawyers. How a very senior lawyer member of the body of benches was able to mentor a one successful lawyer, so that they will see, look, this is how I mentor this person. And also the mentee can also talk to them directly. This is how I was able to learn from my mentor. And I think if you do that, it will help, because the journey is not easy. We know what is happening. There is pressure, there is financial challenge. All these issues are affecting the young lawyers. Most of them, they will tell you, I don't have money to transfer money, or they will tell you, my principal is not paying me well. Although there is a regulation now, but whether the senior lawyers are complying with the regulation or not, that is something else which I don't know what to say. Now, the mentorship benefits both the mentor and the mentee. For the mentee, it provides clarity on which niche to carve out within the profession, because you will learn under your own principle. You will know the area of expertise. That will give you a young lawyer an opportunity to know, okay, do I want to go for corporate practice? or I want to go for full litigation. So, which is an opportunity for the mentee to know that. While for the experienced mentor, it offers opportunity to support the junior colleague in, in finding their fit and also managing professional expectations, challenges familiar to all practitioners. So, and I think the mentoring committee of the body of benchers has a lot to do and need to come up with a lot of programs and ideas. Then, because I have listed the essential attributes of a mentor: expertise, availability, active listening, honesty, respect, strong network, encouragement, patience, which I said that I had to learn it because of my principles, innovation, ethical standards. So these are things that the young lawyers will learn. Now, the second area which I want the body of benchers to focus away from the call to bar ceremony is sensitizing lawyers on issue that has to do with reputation of the profession. When it comes to the issue of misappropriation of clients' money, just like what my brother, the EFC chairman, said, there are a lot of cases. When I Googled this morning, I said, look, AI, give me the list of lawyers that were sanctioned because of misappropriation of clients' money. It brought out a lot for me. I just picked 17. 17. 17. And I went to law report. Brought out the list of decisions. And you find out it went to the extent a lawyer is combating 50,000. As paltry as 50,000. So this is now showing that we have a problem. In one of the cases, which is Omolo Lubas, the state, my Lord Justice Ogunwumijo has this to say. The appellant has desecrated the noble profession by her action. In the circumstances of this case, she has shown excessive greed where she should have been compassionate. As a professional, she was entitled to her professional fees and no more after negotiating the compensation for $100,000 given to the complainant by the Kenya Airlines for the loss of his wife. The appellant took $5,000 meant to assuage the immediate financial suffering of the family and refused to disclose it. After collecting the balance of $95,000, she took another $30,000 and insisted that $65,000 was paid. She refused to disclose all the monies paid to her and deceived the complainant and criminally converting the money to her own use. My lord said that was stealing. This is a reported case. Now, how do we expect members of the public to consider our profession? So, there, for the members of the body of benchers to pay much attention, because this is the area whereby we are having a problem as a profession. And also, in my view, the sanction in the striking lawyers' role, names of the rule is not the solution, because often now they continue to do it. So we need to keep on talking and sensitizing them. The reputational damage, one, to the lawyer as a person, two, to the profession, three, to his family, to his community, so that will make some of us to think twice. And also, like this kind of engagement we are doing, there is need for the body of benchers to allow branches and the judges to have access through Zoom, so that we should not be talking to ourselves. While there is a lecture here, there are programs, so that people can join, so that they will listen, they will hear what is being done here. Just like what Rabana SAN said, as a former insider, most of the meetings of body of benches is quite really boring, because the issues that have been discussed are always the same issues. So there is need for innovation. There is need also for the body to look at the composition. There is need to bring up people of a little relatively young age that have something to offer, so that there will be mix between the old generation and those who are between the generation X and maybe millennials, those who have distinguished themselves, because there are many senior advocates within that range, so that they will help with their own ideas, with their own perspectives. Because, like I said, those of us, we understand how the millennials and Gen Zs think. It will help in the conversation during the meeting of the body of mentors, because otherwise, all the issues be raised. Social media, nobody has power to control social media. You can only counter it strategically, and you need behavioral change to do that. Thank you so much.
Thank you so much, Leonard Silk, for your insight and how practical it is. I believe now that you are dealing with corruption in Nigeria, you are now more patient, I believe. Thank you. Thank you so much. Very quickly, somebody who must be patient is our teacher, and that is Dr. Olugbe Sola Titilayomi Odushote. For everything that we have said about the challenges with the young lawyers and ethics, I'm sure that she sees it literally every other day at the Nigerian Law School. Dr. Odushote was called to Nigerian Bar in 1988, and she has built a distinguished career spanning private practice, corporate law, and legal education, rising through the ranks just recently to become the first female Director General of the Nigerian Law School. Please kindly make her welcome as she gives her insights on this very important topic. Doctor, please.
The chairman of the occasion, KMO Kekereko, my lord, the chairman body of benchers, this Ulukayode, distinguished live benchers and benchers, ladies and gentlemen. I must first of all thank the distinguished body of benchers for inviting me to be one of the panelists at this second annual lecture. And like Mr. Rabaran SAN said, I had the opportunity of reading the keynote lecture, and I agree with him in some instances and disagree. So I'll just take some of them before now lending my own voice to the topic. Now, with regards to sponsorship, we never looked at it as maybe there was a statutory requirement of sponsorship by the members of the body of benchers. And I would say that maybe sponsorship goes to recommending to to be called. And so if he has said now that if you are sponsoring somebody, you cannot also stand in the place of to adjudicate over your candidate that you sponsored, maybe it's time to also reform that aspect and say there's only legal practitioners that are 10 years and above that can sponsor to the bar. Now, what that will mean is that any individual that stands to recommend for call to the bar is also saying that I vouch for this person, I know this person. It will take us away from where, with due respect, justices and live benchers or benchers don't know the number of students. They just collect the forms like my Lord, the Honorable Justice Uwa said, and then sign, and no interaction with the aspirants to the bar. So maybe that can be looked into. Now, the ONSFORD, by reason of the ONSFORD committee, two legislations came out. The Legal Practitioners Act that established the body of benchers, and then the Legal Education Act that established the Council of Legal Education, and by extent, the Nigerian Law School. Now, these are they're two different but different bodies, but they complement each other. One starts where one ends is where the other starts. So I do not think, or I do not agree that the role of the body of benchers is ceremonious. it is what the law has said that they are responsible for call to the bar. I think what we need to talk about is how we can complement each other. In other words, we are talking about institutional collaboration. Now, where, for example, the learned SN, the chairman of ICPC, spoke about mentoring, when would it start? Because at the law school, the truth is that we teach the students. But I've always said that when our students go out on externship, they come back confused or they come back defiant. We send, let me say, a black person on externship. It comes back white. And we say, why are you white? Now, this wasn't how we released you. And it was like, what? I mean, we saw everything in court. So that when mentoring would only come after they have transitioned from the law school. So that while the law school is trying to shape them, after passing the bar final and we have seen them to be fit and proper, then we hand them over to the body of benchers who will now introduce them into or welcome them into the practice that will be regulated by, by the body of benchers, but in particular, the Legal Practitioners Disciplinary Committee. Now, but what we find out is we can't have carryover. I'm like the learned SN Generation X. So I'm close to the Gen Zs. Where we have missed a step, the product that we'll have will be a bit confusing. So that if we're unable to train them properly, we're unable to inculcate in them the morals and the what they need to succeed in practice, it will come back to haunt them. I'm saying this because sometimes we try to discipline to teach and everything, and then some children are being raised to see themselves as exceptions to the rule. It will come back to haunt us when we get into practice. I do not think that life benchers I do not think, well, with due respect, the learned keynote speaker said we should shrink the non-membership. And at the same time, he's made case for his, with due respect, his primary constituency, deans of law and lecturers of law is not necessary. If you are shrinking, then let us shrink. And what will be the basis to include deans of law and law lecturers? I think that, and the problem wouldn't be solved even if we increase the number, because there's something they call the Pareto's principle. There will always be 20% doing everything. So increasing the number will just mean, well, we're increasing the number of 20%, but also increasing the number of the remaining 80 not doing anything. So I think that we need to balance the roles of the Council of Legal Education and the body of benchers. And so when we also look at so that where the law school will prepare the students to come into the profession, the body of benchers will receive them into the profession, and then the legal practitioners disciplinary committee will help them in staying within the bounds of the law. Now, we also need to understand that the LPDC should do more or has a higher responsibility than enforcing rules, because the public, they look at us and we send a message if we are unable to do what we should do in terms of maintaining discipline. Now, mentoring of our aspirants to the bar, I would say, and with due respect for the body of benchers, after dinner speech, the body of benchers should take advantage of that opportunity during the law dinners and make a positive impression on the aspirants to the bar. They see the body of members of the body of benchers. They know about them. We tell them in class, we have them in next week now, we are starting induction across the campuses. We tell them what are the opportunities open to you. We tell them, but I think because they are just Gen Zs, they do what at their own time. Maybe it's like, I'm here at the law school. When I get to that bridge, I will cross it. But I would say that the members of the body of benchers should seize the moment during after dinner speeches and ensure that when the students leave the dining hall, a statement or a phrase will stay with them. The truth of the matter is mentorship by the body of benchers may not be fully effective while they are at the law school, because it is that time that they're the constituency of the Council of Legal Education. I'm not saying that we cannot or we won't collaborate, but I would say that the body of benchers should please give us time. Let us finish, working on them, preparing them to a time when we bring them before the body of benchers for calls to the bar. Thank you very much.
Please, another round of applause for the Director General of the Nigerian Law School. Please, if you can stand up, if you can, I would kindly crave your indulgence to please be on your feet as we do a 1 minute silence for one of our benchers who passed away on January 31st, 2026. I'm talking about Honorable Justice Eugenia Iyizoba, JCE retired. Please kindly. Your soul and the soul of all the faithful departed rest in peace. Please, we can have our seats. Thank you. Very quickly, before I think I know it's a solemn note, but it's also very important for us to recognize the very wonderful work that has been done by this faculty of panelists in dissecting the very erudite scholarly work of Professor Egbewole, Senior Advocate of Nigeria, and I think they deserve a round of applause. And very quickly, I will invite the chairman of the body of benchers, my Lord Honorable Justice Olukayode Ariwoola, JCON, to please come around and present to them their plaques for a job well done. My Lord, please.
My Lord, the Honorable, the Chief Justice of Nigeria, as the chairman of this occasion, we have all heard the paper presented by Professor Wahab Olasupo Egbewole, SAN, the Vice Chancellor of the University of Ilorin. And I'm sure the body of benchers will take time to deal with the paper. Recommendations already noted, and that was why we put Lawal Rabana SAN on this panel of discussants. We appreciate the professor, and we decided you deserve this plaque as an award of appreciation from the body of benchers. The committee is also considering giving you a membership of the body. Thank you very much. Lord, the Chief Justice of Nigeria, the body of benchers is just lucky to have your lordship at the helm of affairs this time around. That's why we can see many of our colleagues from the Supreme Court, and we have one of your best also to lead the discussants, the Honorable Justice Chidi Ebere, who are JSC. We are happy, and that was why we tried to stop the moderator from stopping you. We appreciate your lead, your contribution. It's been wonderful, and that was why the member of the panel kept referring to your lead. Thank you very much.
Thank you. Thank you. Thank you, my lord. Thank you. Thank you. Thank you, my lord. Yes, thank you. The cover.
My Lord, the Honorable, the Chief Justice of Nigeria, the moment your Lordship allowed us to take one of the justices of the Supreme Court as a lead discussant, I said we need to have one of the best of the benchers too, a live bencher, Lawal Rabana. We appreciate your discussion. And I understand because we went through, we saw that the Justice of Supreme Court, who was the one presented by the Chief Justice, was also in the class of Lawal Rabana, SAN, a live bencher. Thank you very much, Lana SAN.
Thank you.
Welcome.
Mr. Chairman of the ICPC from the public sector, used to be a bencher too. He saw it all. He left. We decided to bring him. Come and tell us your experience while you were here, your experience now outside. We appreciate your discussion. We noted your recommendations, and this is presented to you, Mr. Chairman.
Awesome. Thank you.
The last, certainly, but not the least, is the woman who handles them before passing them to the benchers. This is an award of service to Dr. Olugbemisola Titilayomi Odusote, the Director General of the Nigerian Law School. She's the Director General. This is presented to you. We love your contribution. We appreciate it. And your recommendations are noted for action. The body of benchers will get, you are also a member anyway. Noted. Thank you very much.
Thank you so much, my lord. While my lord is still on the podium, may I respectfully beckon on Asiwaju Adegboyega Awomolo, Senior Advocate of Nigeria, to please come around for the next round of the 7 awards to our awardees for today. Former Chairman of the Body of Benchers. Please a round of applause for him as he comes, please. Thank you so much, sir.
Chairman of this occasion, my lord, the Honorable Chief Justice of Nigeria. The presentations to be made. First one is to a worthy successor. If you are a leader and you are not able to produce a successful successor, it is a failure. So I thank my Lord Justice Oluka Edo Ariwola that he did not make this program, this process of reintrospection by the body of benchers a failure. On behalf of the body of benchers, this is an award of appreciation presented to Honorable Justice Oluka Edo Ariwola, GCON, in appreciation and recognition of your service to the body of benchers, Nigeria, 5th day of March, 2026. I congratulate you and I thank you for lifting the veil higher. God bless you, sir.
Thank you so much. Thank you so much. From one chairman to another chairman, and then to the chairman of the occasion herself, the Chief Justice of Nigeria, my Lord Honorable Justice Kekere Ekun, GCON, for our award. Please a round of applause for my Lord.
Lord the Chief Justice of Nigeria, I recall that one of the first projects of the body of benchers for 2025 was the body of benchers signage. And on that occasion, you were very happy that body of benchers have a signage and you commissioned it. It's there, outside there. And all the programs of the body of benchers, you attended, if I could say, dutifully. You attended with all your heart, and you never miss words when you needed to correct us. Today, my Lord, you are the chairman of the 2nd annual lecture of the body of benchers. And I want to present this to you on behalf of the leadership of the body of benchers, led by Honorable Justice Oluka Edo Ariwola. He said, award of service presented to Honorable Justice Kudirat Motomori Olatukumbo Kekere Ekun, GCON, Life Bencher, Chief Justice of Nigeria, in recognition and appreciation of your service to the body of benchers Nigeria, 5th day of March 2026, signed and sealed by Honorable Justice Olukade Ariwola, GCON, Chairman, Body of Benchers Nigeria.
Thank you so much, my lord. Thank you, my lord. May I quickly ask the vice chairman of the body of benchers to please come onto the podium for a short photograph session with the panelists and the leadership of the body of benchers. We will still have a general photo session later, but this is for the panelists, particularly with the leadership of the body of benchers. His Royal Majesty Albert Akpomuje, Senior Advocate of Nigeria. My Lord the King, you are welcome. His Royal Majesty. Renel Silk, thank you. Thank you so much. Thank you so much. As the panelists return to their seats and the leadership of the body of benchers take their seats, we are going quickly to the second segment, the shorter segment of this event, which is the unveiling of the LPDC report. Thank you, my lord. The second part of this event, yes, my lord. Yes, sir. Thank you. Thank you so much. Thank you so much. Thank you so much. Thank you. Thank you. Thank you. A round of applause for them as they take their seats. Thank you so much. We acknowledge the members of the bar that are here in their numbers. Thank you so much for coming to the body of benchers event. That's not something you will do every now and again, so it's a privilege. Thank you. My lords, distinguished benchers, ladies and gentlemen, the second part of this event is the public presentation of the report of the directions of the Legal Practitioners Disciplinary Committee, the LPDC. At the bar, it is often said, perhaps half in jest, that the fear of the LPDC is the beginning of wisdom. Yet, beyond this cliche lies a deeper truth. Ethical discipline has always been at the very heart of the vision that gave birth to the body of benchers. My noble lords, distinguished benchers, while preparing for this moderating assignment, I had the privilege of engaging a distinguished legal historian and bencher, Mr. Lanre Akishola, SAN, widely known by his pen name Onigege Wura, on the origins of the body of benchers. He was kind to share with me Amazing Grace, the memoirs of the late Honorable Justice and Etiquette. Many students graduating from Nigerian universities did not yet fully appreciate those traditions. The solution, as my Lord Roger envisioned, was for students to learn directly from and follow the footsteps of the most distinguished members of the profession, our great lawyers and jurists. That recommendation was accepted, and a committee chaired by Honorable Justice Adeyinka Morgan was constituted. Its work ultimately led to the establishment of the body of benchers as we have it now in 1971. From the very beginning, therefore, the body of benchers has stood as the guardian of professional discipline, ethics, and standards at the Nigerian bar. It is thus particularly gratifying that who also serves as the editor-in-chief of the body of benchers law reports editorial board. I'm speaking of no other person than Chief Dr. Charles Onwesuyi Edosowan, Senior Advocate of Nigeria, the Obasuyi of Benin Kingdom. Please, round of applause for him. May I now respectfully invite another distinguished leader of our profession, a leading light in this profession of ours, who happens also to be the Deputy Editor-in-Chief of the body of benchers law reports editorial board. Dr. Onyechi Ikpazu, Senior Advocate of Nigeria, OON, to deliver the editor's remarks. Leonard Sok, sir. Thank you so much, Leonard Sok. For the editor's remarks.
I know it's 5 minutes.
5 minutes.
The chairman of the occasion, my Lord, the Honorable Justice Kekereku, the chairman body of benchers, the president of the Court of Appeal, my lords, please permit me to adopt the order of protocol so ably laid down by my Lord Honorable Justice Ariwola. I have been mandated by my chairman, the chief editor, Dr. Charles Uwensu Edosonwo, Senior Advocate of Nigeria, to present a speech on behalf of the body of benchers Law Reporting Committee. It is with profound humility and unwavering appreciation of the solemn traditions of our noble profession that I, on behalf of the Law Reporting Committee, present the 2025 edition of the report of the directions of the Legal Practitioners Disciplinary Committee. In the past 3 months, our committee has worked round the clock to ensure that this publication became a reality. We are grateful to the chairman of the body of benchers, His Lordship, Honorable Justice Ariwola, GCON, for his exemplary leadership and support, and of course, to the efforts of the immediate past chairman, Asiwaju A.S. Awomolo, Senior Advocate of Nigeria. Without their tenacious resolve, this report would have remained a pipe dream. We are equally grateful to the Legal Practitioners Disciplinary Committee, whose directions provide the raw materials for this publication. We must particularly commend His Lordship, Honorable Justice Dr. Ishak Bello, the chairman of the LPDC, and of course the members, including Chief Ume Kalu, Senior Advocate of Nigeria, for their selfless service. This 2025 volume is a bumper edition. It contains 35 reportable directions of the committee delivered between December 2024 and December 2025. The directions in the reports would have been more, save for the fact that we exercised our editorial discretion to leave out a few of the directions for the time being. The legal profession is not merely a means of livelihood or an occupation. It is a sacred trust. We are, as the cliche goes, ministers in the temple of justice. We are custodians of rights and privileges. We are guardians of liberty and pursuit of happiness. And above all, we are officers of the court. The Legal Practitioners Disciplinary Committee stands at the very heart of that sacred trust. Constituted under the Legal Practitioners Act and operating under the auspices of the body of benchers, the committee embodies the profession's collective resolve and obligation to uphold honor, discipline, and ethical rectitude. This publication is therefore not a mere record of infractions and sanctions. It is a testament to institutional integrity. It is evidence that Nigerian bar possesses both the courage and the capacity to regulate itself. It affirms that no member of the profession, however elevated, is beyond scrutiny where professional ethics are concerned. This edition builds on the foundation ably laid by the first. As in the former, it reflects evolving jurisprudence in matters of professional conduct. It highlights emerging ethical challenges in contemporary practice. It clarifies principles governing fiduciary responsibility, conflicts of interest, duty to court, duty to client, and the preservation of the dignity of the profession. In an era where public confidence in institutions is increasingly fragile, the transparency of disciplinary decisions is not optional. It is of utmost necessity. It is essential. Accountability strengthens credibility. Documentation strengthens consistency. Publication strengthens education. In reviewing these decisions, certain themes became evident. One, the duty of candor to the court. Two, the sanctity of clients' funds. Three, the prohibition against conflict of interest. Four, the responsibility of diligence and competence. And finally, the obligation to uphold the dignity of the profession both in and outside the courtroom. These are not mere technical rules. They are the pillars upon which the temple of justice stands. In a time when public scrutiny of institutions is intense, the legal profession must not only be just, it must be seen to be just. Transparency in disciplinary proceedings strengthens the bar. For the young lawyer newly called to the bar, this report is a compass. For the seasoned practitioner, it is a reminder. For the bench, it is a reference, and for the public, it is a source of reassurance. Of the 35 directions published in this report, in 18 of them, the respondent legal practitioners were found wanting. In effect, the indicted legal practitioners were found guilty of infamous conduct in the course of the performance of their duties as legal practitioners. 3 of the indicted practitioners had their names struck off the roll of legal practitioners. 3 were suspended for 5 years. 2 were suspended for 4 years. 5 were suspended for 3 years. 4 were suspended for 2 years. And the last one was given a warning. This chronicle underscores the seriousness and solemnity with which the body of benchers approaches allegations of breach of the rules of professional misconduct. Thus, discipline within the profession is not driven by vindictiveness, but by fidelity to principles. It is not an exercise in punishment, but an affirmation of standards. It is not an indictment of the bar, but a reinforcement of its nobility. May this work serve to deepen ethical consciousness within our ranks, and may it strengthen adherence to the rules of professional conduct, and may it encourage every practitioner to remember that reputation takes years to build and only moments to diminish and devastate. Finally, this 2025 volume has been deservedly dedicated to my chairman, that is the chairman of this committee, Dr. Charles Uwensui Edosonwo Obasuyi, Senior Advocate of Nigeria of the ancient and sacred Kingdom of Benin. I must admit that the decision to honor him with this volume was a coup orchestrated by the committee members without his consent. We had intended to honor him with one of the first 4 volumes, an offer which he bluntly refused. This time around, he was not informed before we went to the press. Mr. Chairman of the Electoral Committee, we thank you for your leadership and encouragement. We must also acknowledge the indefatigable role played by all the members of the committee. I make special reference to my Lord, Honorable Justice Chidiebere Ngoma Owa. And that Ngoma, I believe, means a good child, right? Thank you. Of the Supreme Court of Nigeria. And also His Lordship Honorable Justice Kazim Aloba, the Chief Judge of Lagos State. And then to the entire members. I speak for the editor-in-chief and of course for myself that it has been a pleasure working with all of you. May this report inspire greater professionalism, deeper integrity, and renewed commitment to the ideals that define us as ministers in the Temple of Justice. Long live President Bola Tinubu, Federal Republic of Nigeria, and of course, the Nigerian Bar Association. Thank you so much.
Thank you so much, Leno Silk, and long live the body of benchers also. Thank you so much. And it's very important that we acknowledge the work that has been done by the editors of this very important report. In that regard, just like the Deputy Chairman of the Editorial Board has noted, we thank my Lord Honorable Justice Uwa, Mr. Murtala Aliyu Kankia Esquire, Lady Gloria Umoren, Honorable Justice Kazim Alugba, Professor Sylvia Ifemije, Honorable Attorney General of Anambra State, Mr. M.Y. Abdullah, Senior Advocate of Nigeria, Attorney General of Kogi State, Anuzia Obinaya Obi Esquire, Mrs. Umfon Usoro, Dr. Amechi Chukwudebe Okwosa, Mrs. Becky Samuel, Mr. Adeshino Adigbite, and of course, Mr. Daniel M. Teller. Please, a round of applause for all the editors of this report. And very quickly, may I crave the indulgence of the Chairman of Education, my Lord Honorable, the Chief Justice of Nigeria, and the Chairman of the Body of Benchers for the unveiling of this very important report. In that regard, may I invite to the left side of the podium where the law reports are, the Chairman of the Body of Benchers, my Lord Honorable Justice Ariwola GCON, my Lord the Chief Justice of Nigeria, the Vice Chairman of the Body of Benchers, the immediate past Chairman of the Body of Benchers, Chief E.S. Awomalo, Senior Advocate of Nigeria, the President of the Court of Appeal, Mazi Afa Musigwe, the MBA President, and the Chairman of the Editorial Board himself, the honoree of this particular edition, Chief Edosoan, and of course the Secretary of the Body of Benchers for the unveiling of the LPDC report. Please. Please, a round of applause for them as they come. No fireworks, please.
I congratulate the entire members of the board of editors of this of the 2025 direction of the Legal Practitioners Disciplinary Committee. I commend you for a job very well done. I commend the body for initiating the publication of these directions and for the present executive for sustaining it. And by the grace of God, it will continue to be a guide for us. Yes, and members of the LPDC, thank you very much. So to the glory of God and to the promotion and maintenance of standards and ethics in the legal profession, it is my honor and privilege to unveil the 2025 edition of the reports of the direction of the Legal Practitioners Disciplinary Committee. Very well done, and thank you.
Thank you so much, my lord. Thank you so much. Please a round of applause for my lord the CJN and my lord Honorable Justice Ariwola and the leadership of the body of benchers that have. You would recall that 4 editions were published last year, and I understand from the secretary that there is actually a subsidy on those four. Those four can be gotten just outside this hall for a paltry sum of 20,000 naira, while the new direction can be gotten for 10,000 naira. And I'm sure that subsequently it would also be on every. We decided to make this very cheap, just so that the ignorance of the directions will not be an excuse for any legal practitioner. You know that for you to get NWLR, a copy is 4,000 naira now. So this is a good one if you can get this for just 20,000 naira for 4 copies. And this is actually direction, and it's actually bigger, as you can see. Thank you so much for the good work that has been done. So very quickly, I would invite to this side of the hall for a photograph session as we almost close. My Lord, the Chief Justice of Nigeria again, my Lord, I'm sorry. The Chairman of the Body of Benchers, all the justices, my noble lords of the Supreme Court of Nigeria that are here, the former Chairman of the Body of Benchers, everybody seated on the front seat, and our distinguished live benchers that are here for a photo session just right here on this part of the hall. Please, if you can kindly just stand up for that, so that we can quickly leave this place. I've been asked that for the photographers have requested that all judges of the Supreme Court and everyone in front should first take a picture, while subsequently the live benchers can join. And I understand also, actually, I can still come. Live benchers can come around and stand behind. We can stand behind my lord, sir. Thank you. Just here. Yes, sir. So can I just have one full picture? Apparently, we can stand behind here. Thank you so much. You all have been a wonderful audience today, and we are grateful to have you. My noble lords, distinguished benchers. Yes, sir. Some of us can actually come behind. We can come behind. We can come behind to the on the podium. We can come behind the. We can come behind there. Yes, we can come behind. Thank you so much. We can come behind. The live benchers, Mr. Kankia, the ICPC chairman, please. You can come behind here to take the picture, please.
Yes, let's go.
Yes. You're welcome, sir. Yes, you can come behind. You're welcome, sir. My bonnie be. Okay, bon. Thank you so much. As we return to our seats, and as the Chief Justice of Nigeria returns to her seat, we'll be taking the national anthem. As soon as she returns to her seat, we'll be taking the national anthem. Oh, sorry, please. But before the national anthem, may I respectfully call on the Vice Chairman of the Body of Benchers, His Royal Majesty Albert Akpomuje, Senior Advocate of Nigeria, for a brief vote of thanks on behalf of the leadership of the Body of Benchers for this very successful event. His Royal Majesty Albert Akpomuje, Senior Advocate of Nigeria, for a very brief vote of thanks. Please, if we can kindly take our seats, we are rounding up. As the Vice Chairman of the Body of Benchers, give a vote of thanks on behalf of the leadership of the benchers.
The chairman of the Body of Benchers, the chairman of this occasion, the Chief Justice of Nigeria, live benchers here present, ladies and gentlemen, my task is a very simple one: to appreciate all of you for being present at the second annual lecture of the Body of Benchers. First, let me appreciate on behalf of the Body of Benchers the guest lecturer, Professor Wahab Egbewole SN. Prof, we really appreciate your research, your delivery, and I will say some radical recommendations to the Body of Benchers. Like the chairman of the Body of Benchers said, your recommendations are noted and they will be acted upon. But we really appreciate you for the time, the sacrifice which you made to make this lecture possible. And to the discussants, we also appreciate you for your contribution to the topic, the theme of the lecture, which was presented by the guest lecturer. We must commend our chairman for ensuring that this lecture, which started last year, this being the second, did not just end with the first one, but ensured continuity of the lecture. My Lord, we thank you so much for approving this, and we hope that it will be something that will be done every year. Our special thanks goes to the chairman of the occasion, His Lordship, the Chief Justice of the Federation. We know how busy you are, and for you to have found time to share this occasion, we say a big thank you. And like the immediate past chairman of the body of benchers said, that you dutifully attend all our events. We appreciate you for that. My Lord, the President of the Court of Appeal, we appreciate you for being present, and also the Honorable Attorney General who has the Chairman of EFCC is coming. We appreciate the representative of the Federal Capital Territory Minister for the goodwill message. And also the chairman of the Welfare Event and Program of the Nigerian Bar Association. We appreciate all of you, because if you will not hear, the success we have recorded today will not be possible. We thank you for leaving your very busy schedule to be here with us. And on behalf of the chairman of the body of benchers, we wish each and every one of you safe journey to your various destinations. And God
Benchers, please, we're about to take the national anthem, and I will crave your indulgence to please stand up if you can for the first stanza of the national anthem as we close the session. Thank you so much for coming, and it's been a privilege hosting you today. God bless you. The national anthem, please. Thank you so much, and God bless you. Thank you.